Hey, what's up, what's up, what's up? How you doing? How you been? What's going on? What's good? How you getting it in? Body getting it funny? What's going on, people? Okay, it's May the 31st, 2007. This story takes place in Wisconsin, and the trans kid name is Ash Carter. Now, this is how the story goes. Victory for a trans right and federal appeal court. The Seventh Circuit became the first federal appeals court to base on a ruling of the trans student's right on a Title IX and the U.S. Constitution. It appears court that the major victory for the rights of the trans student, a federal appeal court today upheld the Wisconsin trans boy right to use the boys' restroom at its school. The unanimous three-judge panel at the U.S. Court appeared on the Seventh Circuit kept in place on federal district court preliminary injunction that the preventing Wisconsin Kenosha Unified School District Number 1 for enforcing the anti-restroom policy while student Ash Carter case proceed, the Washington Post reported. Now, Carter had sued the district last summer, arguing that the district policy required him to use the girls' restroom on gender-neutral location in the school office and violated his civil rights. There were options that Whitaker said that him apart from his peers and stigmatized him stigmatized him from becoming the gender identity, the Post reported. Now, the Pierce Court decision does not rely on Obama's administration of 2016 guidelines and the treatment for trans student guidelines that Trump administration is now rescinded. The guidelines advise that the student district to allow trans students to use the restroom of their facilities of their choice and use the student's preferred name or pronouns, and in order to avoid validating an anti-discrimination law under the President Obama, the Department of Education and Justice that held that the Title IX of the Education Amendments of 1972 and banning sex discrimination in education by definition ban on discrimination based on gender identity. So officials with the departments craft the guidelines accordingly. The Seventh Circuit agreed that both Title IX and the U.S. Constitution ban gender identity discrimination, that the first federal appeal court to do so, and that Carter was likely to succeed in his lawsuit on the biased Obama administration. Officials that helped develop the guidelines said that the court decision shows that there were interpreting Title IX according to that discrimination against trans students was unlawful with or without the guidelines, that the guideline didn't make the new law, which was our point Catherine, who helped put together the guidelines at the Education Department, told the Post. Another federal appeals court, the Fourth Circuit, had ruled in favor of the Virginia trans boy Gavin Grimm right to use the boys' restroom at his school, but it had bias to his decision largely in Obama's era guidelines. His school district in Gloucester County appeared in a decision to the U.S. Supreme Court, which was going to take up until the guidelines were revoked. When that happened, the High Court sent the case back to the Fourth Circuit for reconsideration. The Seventh Circuit decision is to precedent settings for 3 states. It covers Wisconsin, Illinois, and Indiana. It also may influence other courts, legal experts says. Other courts, as will be grasping to the same issue, will hopefully find that the Seventh Circuit decision very persuasive as they look to the answer of questions elsewhere. Lawyer Joseph, who represents Whitaker, along with the Transgender Law Center, told the Post that this is a great victory for transgender student Ada Chris, the Transgender Law Center executive director, in a press release. The battleground may be bathroom, but the real issue is fairness in transgender people, ability to go to school, to work, and simply exist in public places. This win makes that more possible for more people. Whitaker will graduate from high school this weekend, so the decision impact on him is limited, but he still saw that important victory. I am thrilled that the Seventh Circuit recognized that my rights to be treated as a boy that I am in school, he said, at the Transgender Law Center, after facing daily humiliation in school last year and also being threatened. Now, with the discipline and being constantly monitored by school staff just to use the bathroom, the district court injunction that September allowed me to be able to be allowed to have typical senior in high school and so focus on my classes, after school activities, applying to colleges, and building lasting friendship. Now, the school district is considering whether to appeal the decision to the Supreme Court on the full Seventh Circuit and whether to proceed with the case in the district court, a lawyer for the Kenosha school told the Post. So congratulations, baby brother Ash, and you out of school now. And thank you, Mom, for standing behind your child. You are a beautiful woman. And I love to hear feedback, and I want to tell you thank you for watching Catch the Rave. I love you.